Hi, my name is Richard Sherrill. I'm an attorney with the Clark Partington Law Firm practicing in Pensacola and Destin. I'm also a member of the Executive Council of the Real Property, Probate, and Trust Law section of the Florida Bar. I want to discuss an important feature of the new law that came into existence this year, which is remote online notarization. That law allowed us to use an electronic platform for online notarizations by an approved remote notary effective January 1, 2020. There was a delay in what type of documents could be executed with the remote online notarization for essentially estate planning documents. That law, which will now come into effect and be proper and lawful, it takes effect July 1. So as we approach that date, it's important to focus on one aspect of that law to bear in mind when using this new platform. The new provision of the law that comes into effect July 1, 2020 allows estate planning documents to be executed using the remote online notarization platform. This essentially allows a remote online notary to supervise remote witnessing of an electronic will. This applies in cases of, it pertains to a will, a trust with a testamentary aspect, durable power of attorney with estate planning functions that we typically call the superpowers, also execution of advanced care directives, living wills, for example, and also documents that are a waiver of spousal rights, a premarital agreement, a postnuptial agreement, for example. These documents can now be executed using the remote online notarization platform effective July 1. But there is an exception where remote witnessing is inapplicable and inappropriate and not available for execution of estate planning documents. The will, testamentary trust aspects, durable power of attorney with superpowers, advanced care directive, and also marital agreements. And that is where the principal signatory, whether that's the testator or the settlor, for example, is a vulnerable adult. Where the principal is a vulnerable adult, remote witnessing is ineffective, and instead witnessing must be in person. Documents executed by a vulnerable adult, documents of the type we've discussed, estate planning documents, that are executed in the presence of remote witnesses only are invalid. They are not effective and they are invalid and must have in-person witnessing. So the point of our discussion today is what constitutes a vulnerable adult in this context, such that remote witnessing would be unavailable and the documents would be invalid if done so. The Chapter 285, details the execution of these documents. And for a testamentary document, first, the online notary must ask a series of 3 questions. And those questions are whether the principal is under the influence of any drug or alcohol today that would impair their ability to make decisions. The second question, do they have a physical or medical condition, do they have a physical or mental condition or long-term disability that would impair their ability to perform the normal activities of daily living? And the third question is, does the principal require assistance with daily care? After receiving an affirmative response to each of those, that they are not a vulnerable adult based on those 3 questions, the online notary would then read the following notice. If you are a vulnerable adult, as defined in section 415.102 Florida statutes, the documents you're about to sign are not valid if witnessed by means of audio-video communication technology. If you suspect you may be a vulnerable adult, you should have witnesses physically present with you before signing. Then, if we've gotten clearance on the 3 questions, if the online notary has read that notice verbatim, and if there's no other indication of a vulnerable adult, the process can continue. However, even if we get past those hurdles of the questions, the notice, the person who's executing the documents could still be a vulnerable adult. We just might not know until the document is put to the test, whether that's a power of attorney being used or after the principal has died, when the will is admitted to probate or asked to be admitted to probate. So what constitutes a vulnerable adult is very important. Chapter 415.102 of the Florida statutes defines the vulnerable adult. It's the section of the law dealing with adult protective services. It defines a vulnerable adult as someone who is an adult, 18 years or older, whose ability to perform normal activities of daily living or to provide for their own care or protection is impaired due to mental, emotional, sensory, long-term physical or developmental disability or dysfunction, brain damage, or the infirmities of aging. Activities of daily living is further defined in several instances of the Florida statutes or the rules. With regard to assisted living facilities, for example, or adult family care homes for disabled adults, this includes functions and tasks for eating, bathing, grooming, dressing, walking, transitioning, and toileting. So these are basic functions of daily living. Putting this together, if after being provided the requisite notice by the online notary, the questions being asked and being able to get past those as to whether they are a vulnerable adult due to drug or alcohol use, physical, mental, or disability impact normal activities of daily living, or requiring assistance with daily activities of living, the question still remains whether the person in front of the remote online notary and the online witnesses might still be a vulnerable adult. If they are, then the documents are void as to the online witness presence, and those documents would be invalid. We'll most likely know a person is a vulnerable adult if they answer affirmative to any of the three questions, or if after hearing the notice, they stop the proceeding. But without an admission of being a vulnerable adult or the notice being taken seriously and heeded by a vulnerable adult, we may not know that the person who is using the online platform for an electronic will, testamentary aspect of a trust, power of attorney, advanced care directive, or a marital agreement, whether that person is a vulnerable adult, in which case the online witnessing would be invalid and the documents would be of no force and effect as to those witnesses. So it is very important as we get towards July 1, 2020, when remote online notarization is available, the platform is available for supervision of remote witnessing of an electronic will, essentially, that we keep in mind the very important warning that vulnerable adults are not able to use remote witnessing to execute these documents. Thank you very much.